In this lesson, what we're going to do is move on away from talking about negligence in its generality towards examining what negligence looks like in terms of some of the subsidiary issues pertaining to the tort of negligence. We're going to begin in this lesson and in the next few lessons looking at the idea of psychiatric injury, or the validity of claims for psychiatric harm, and then we will also talk about pure economic loss. These are the sort of two general subsidiary issues which are often spoken about and mentioned when we talk about the concept of negligence. So, as I mentioned, we're going to divide the next few lessons into conversations about psychiatric injury and then conversation about pure economic loss. So, beginning then with psychiatric injury. As you may suggest, as you may understand from the name cited here, psychiatric injury involves claims that exist for conditions which are more than merely physical. So, thus far, when we have been talking about various different cases, we've been talking about damage which is either physical injury or potentially damage to some kind of property. But for the most part, we've been talking about something which is physical in some kind of way. So, for example, the case of Donahue and Stevenson involved an individual who had been made ill as the result of drinking from that bottle of beer, of ginger beer. Psychiatric injury, as you may suggest, is one which looks to conditions which go beyond the mere physical. Claims for psychiatric injury relate to psychiatric conditions of things relating to mental problems that people have as a result of various different things happening to them or witnessing various different things. Now, this takes it from the more tangible element of physical injury to the less tangible of psychiatric injury, because it's a little bit less easy to understand and to really quantify psychiatric illness compared to physical damage. How do you, for example, quantify the development of PTSD versus the breaking of an arm? These seem to be very difficult to do in comparison to each other. So the difficulty with claims for psychiatric injury is this intangibility in the illness itself. And it should be noted that the idea of psychiatric injury could have potentially opened the doors to a near unlimited number of claims. Imagine, for example, there is a car accident that is caused by negligence, okay? And the result is an individual is very brutally, heavily mutilated. And this is seen by 1,000 people, and 1,000 people are witnessing this event and they are traumatized by this event. Could that 1,000 people then claim individually against the individual who had caused the accident, owing to the fact that they had caused psychiatric injury to all of these people? That's one example, a hypothetical example and a hypothetical scenario, but it is one that essentially talks about one of the issues that is had with psychiatric injury, the fact that when it comes to claimants, there could be a potentially near infinite number of them. And so as a result of which, the courts have been very, very reticent to be able to essentially limit, insofar as possible, the ability of people to make claims. So the first question that is asked when it comes to psychiatric illness is whether or not the individual person in question will have a good claim at law to actually bring a tort action against the defendant. And the first consideration in answering that question is whether or not the claimant has a recognized psychiatric illness, or potentially just has some kind of psychological distress, or maybe some grief which has been caused by the event which occurred. One of the things that is important to note is that the distinction between the two is a distinction between where and where not, where there will and will not be a remedy at law. The latter does not give you remedy at law. The former, the recognized psychiatric illness, could potentially give you a claim in tort, but the idea of just having general distress or grief would not give you a remedy. So the idea of a recognized psychiatric injury or a psychiatric illness is the key way in which the courts have been able to not only look at who can claim, but also limit and control the number and types of claims that are brought before them, so as to ensure that there isn't a floodgates of litigation in relation to this particular area. We shall get into more detail as to what this means as time goes on, but there are a number of cases which have identified what are known as recognized psychiatric conditions. So, for example, mere grief or mere distress or just the loss of a loved one does not in and of itself constitute a recognized psychiatric condition, according to Lord Oliver in the case of Alcock. We'll get to Alcock in the future as well. It is generally this case that a recognized psychiatric injury requires some kind of recognition by a professional and a clear diagnosis. So something like post-traumatic stress disorder could count as a recognized psychiatric injury. Something like distress or unhappiness would not. Today, and ever since the case of White versus the Chief Constable of South Yorkshire, there are broadly three categories of claimant in these cases. The first is an individual who suffers a physical injury which gives rise to a psychiatric injury. So there is a physical and psychiatric injury, and one can essentially get a claim from the result of the other. The second are those who do not suffer physical injury, but they are put in danger, such that they develop a psychiatric injury. So if you are put in such a horrific kind of danger that you develop, for example, PTSD as a result, and the danger was caused by the negligence of the defendant, then this could give rise to a claim in psychiatric injury. And then finally, you have those who are not in danger, nor do they have any kind of physical injury, but they witness some kind of traumatic event which could give rise to a claim. These are the least, the lowest claims in terms of being able to try and find some kind of psychiatric injury claim in torts. Now, one of the earliest cases on this issue was the case from 1888 of the Victoria Railway Commissioners and Coltas, because what this case represents is the old law on what we're going to call pure psychiatric injury, i.e. psychiatric illness which does not have with it and attached to it a prerequisite physical injury. In this case, the defendants had been a gatekeeper who had carelessly left a gate open, and that this gate obviously would allow people to go through, some of which were the claimants. This would leave them to driving across onto a level crossing when a train was coming. And they were not hit by the train. There was no physical injury, but they were so close to being hit by the train that they were traumatized by the fear of death and danger, and so they wanted to make a claim on the basis of that kind of fear of death and danger. It was without a doubt the case that they had been careless, the defendants, in leaving the gate open, but could the claim succeed on the basis that there was no physical injury? Well, it was denied by the Privy Council that any psychiatric injury could occur without this prerequisite physical injury, and therefore their claim failed. This is the old law on the matter of pure psychiatric injury. Today there are claims that you can make on the basis of pure psychiatric injury without the prerequisite physical injury, but they, depending on the circumstances, are more and more difficult to make in terms of being able to actually get some kind of remedy in law. Welcome back, everybody, to the Law of Tort. We finished the previous lesson talking about the old law on the question of psychiatric injury and psychiatric harm, talking about the concept of there at least originally being no potential ability for an individual to actually make a claim on the basis of pure psychiatric injury. Now, in this lesson, what I'm going to do is talk about the development of the case law on this issue, talk about how we see future cases start to build on those that had previously been established in being able to come up with some kind of conclusion in relation to the development of psychiatric injury as a substantial principle of law. As I mentioned, we finished by looking at the old law on the idea of there being a failure in a claim of psychiatric injury in the case of Victoria Railway Commissioners and Coltas. Remember, that was the case where an individual had negligently in their duty of care, breached said duty of care in essentially leaving a gate open, which allowed people to drive over a railway track. They were very, very nearly hit by an oncoming train as a result of this negligent action, and they were traumatized as a result of the event that had taken place. Now, they argued that as a result of this traumatic experience, the trauma itself can represent damage by way of pure psychiatric harm, and so therefore they could make a claim in negligence as a result. But of course, the courts said, no, you can't make a claim in negligence on the basis of pure psychiatric harm. There has to be an attached physical injury to that particular element as well. This lesson is going to talk about a number of cases which has seized the essential expansion on the concept of psychiatric harm being a claimable issue within the law of torts, specifically within the tort of negligence. We're going to begin with a case that takes place a few years after the Railway Commissioner's case with Delio and White from 1901. In this case, you have a pregnant barmaid who had suffered shock, and as a result of this shock, they therefore had a miscarriage. Now, the shock was caused by a defendant who had negligently been driving a carriage which had then crashed into the pub where she had been working. So, to set the scene, you have a pregnant barmaid. She's working behind the bar at a pub, and a person, a driver of a carriage, was negligently driving and crashes into the front of the pub, which causes the barmaid to have quite significant shock as a result of the event. That shock then subsequently leads to a miscarriage. It was held that the concept of psychiatric injury being limited purely on the basis of potential fraudulent claims was actually an unwise position that the law could take. Such a course involves the denial of redress in meritorious cases, in cases which have merit, and it necessarily implies a certain degree of distrust, which I do not share, in the capacity of legal tribunals to get the truth in this class of claim. So essentially, this case illustrates that the courts were quite hesitant and relatively disagreeable when it came to limiting psychiatric injury and to limiting potential claims for psychiatric injury on just the basis of fraudulence. So to suggest that we're going to limit psychiatric injury claims, okay, well, we're going to do it only because they could be potentially fraudulent. That is seen to be something of a limitation in the law. And it also seems to be the case that the courts are not trusting themselves to be able to identify meritorious cases and to be able to distinguish between them and fraudulent ones. In 1925, we see another case that relates to the concept of psychiatric harm. This was another case involving a pregnant woman. This time, this pregnant woman had witnessed, a lorry roll down a hill without a driver. The lorry sort of rolled down the hill and then sort of round a corner beyond her field of view. So when it went out around the bend and out of sight, it then crashed to an area where she had just dropped her children off at school. So one of the things that should be noted is that she did not see the crash. She didn't even know at the time that it was her children that could have been injured as a result. Her shock from the possibility that the lorry may have injured or killed her children caused her to have a miscarriage. In reality, only one child suffered some injury as a result of this event, but the idea that they could have all been injured or that they could have been killed as a result of witnessing the lorry rolling down a hill causes her to have a miscarriage from the shock and the psychiatric harm that was caused. The claim in psychiatric injury would actually succeed on this basis, and it would be consistent with the precedent that was set in the case of Delio, because that was also a case where you see psychiatric harm be established and the case also succeed. They were both similar cases. In 1943, then, we get another case, the case of Borhill and Young. This case represents something of a contraction of the principles that we see in the previous cases. So the case law on psychiatric injury seems to expand and expand and expand, and then the case of Borhill and Young sort of reins it back a little bit and restricts some of the abilities to make claims. Again, it involves a pregnant woman. This pregnant woman was getting off a tram. At the same time, but on the other side of the tram, outside of the field of view of the woman, and actually quite far away, a motorcyclist would actually hit a car, and the rider of the motorcyclist would be killed as a result. Now, the woman did not see the collision. She was in no way in any kind of danger herself to actually have been to have collided with anybody. All she had seen was the resulting blood, which was on the ground, on the pavement, as a result of the collision. This is what caused her to go into shock, resulting in the stillbirth of her child. Now, the question here is, could she claim on the basis of psychiatric harm, owing to the fact that the driver or the motorcyclist had been negligent in their action, and so was caused the accident? In her position as a mere bystander, it was held that she could not claim in negligence. She was in no danger herself, damage to her had not been reasonably foreseeable, and there was no view that she could have essentially made a claim by way of some kind of secondary victim, by witnessing a traumatic event which involved somebody of someone with close ties of love and affection, unlike the previous case of Hambrook and Stokes. Finally, then, let's look at the case of McLaughlin and O'Brien from 1983. In this case, you have a a claimant who was a mother, and she had learned via a phone call of her family being in a car accident, the rest of her family, which involved a husband and some children. When she arrived at the hospital, she'd seen the injuries which were incurred onto her family members, as well as the news that one of her children had died as a result of the accident. So a particularly traumatic event. She would then suffer from depression as a result. This is the recognized psychiatric condition that is necessary as a prerequisite for making claims in psychiatric harm. Now, it was held that her claim would be successful, as she would be something known as a secondary victim for the purposes of psychiatric injury. Now, we're going to get into the distinction between primary and secondary victimhood as time goes on, but one of the things that should be noted at the moment, just as a basic overview, is that there was the relevant time, there was a relative proximity to the traumatic event, as well as a perception of the aftermath of the event. There was also a relatively close connection to the people who were victims in this event, i.e. these were family members. And so all of these contribute to this idea that a secondary victim could be established on the basis of psychiatric harm. In the last couple of lessons, what we've been doing is talking about different principles of the law of torts, focusing on the tort of negligence and one of the subsidiary issues therein, which is this idea of psychiatric injury or psychiatric harm. This lesson is going to talk about one of the major considerations that has to be made in relation to psychiatric harm and whether or not a claim can be valid for psychiatric injury. This is looking at the distinction between primary and secondary victims, focusing first on the concept of the primary victim principle. So far we've explored a whole series of different cases involving psychiatric injury in the tort of negligence. This lesson is going to talk about the test which is established to determine whether or not a successful claim exists for primary victimhood, or primary victims. And then we'll look in the next lesson at the concept of secondary victimhood and the rules that are presented there. So what does it mean to be a primary victim? Well, generally speaking, the test for establishing a primary victim is that the defendant in question, or at least the claimant in question, should I say, be placed in some form of immediate danger, and that danger is caused by the negligence of the defendant. Remember that in all of these cases, in all of these claims, the idea of damage is what we're talking about. We're talking about the concept of being able to claim for psychiatric harm. So in all of the instances, the cause of the harm and the cause of the danger and the cause of anything, okay, has to be the result of negligent action. It has to come from negligence. So assuming that there is negligence, then can the psychiatric recognized psychiatric condition that may have been caused as a result of said negligence give rise to liability by way of psychiatric harm? That is the general rule. The most authoritative case on this issue is the case of Page and Smith from 1995. This case involved a minor car accident where one car would negligently collide with another. Again, the idea here is that there is negligence involved. Despite the fact that there was no physical injury that was incurred, the claimant argued that this had led to the recurrence of something known as chronic fatigue syndrome. This was something that the claimant had previously suffered with, but had the symptoms of which had alleviated over time. However, following this minor car accident, which was the result of negligence, there was this idea here that the chronic fatigue syndrome had returned, or at least the symptoms of which had returned. The issue here, and the question of law, was whether or not the defendant had a duty of care towards the claimant in reference specifically to the damage suffered. So the damage suffered wasn't necessarily any physical damage, because it was a minor car accident. We're talking about the damage that is incurred by the idea of the chronic fatigue syndrome, something which the claimant had previously suffered. It was held in this case by majority in the House of Lords that the defendant did have a duty of care with regards to chronic fatigue syndrome. The basic argument that was presented was that there should not be a delineation made between physical and psychiatric injury when we are talking about reference to the law. As such, if it can be shown that there is and there was reasonable foreseeability with regard to the physical injury, this mere fact, the fact that there should have been reasonable foreseeability in relation to physical injury, then the mere fact that this was the case would be sufficient to show the foreseeability of psychiatric injury as well. So in the case of Page and Smith, it establishes the view that there shouldn't be this delineation of rules applied when it comes to physical versus psychiatric injury. If you could come to the conclusion as a court in saying that there was reasonable foreseeability in relation to the fact that the defendant should have reasonably foreseen the damage that was caused by their negligent driving, if that was physical, then you could also make the same application to that of it being psychiatric as well. In the previous lesson, what we did was talk about the concept of primary victimhood when it comes to psychiatric harm for negligence cases in the law of tort. Now, we make a distinction and a delineation between primary and secondary victims in the law of tort, and what we're going to do in this lesson is talk about the latter of the two. We're going to talk about the concept of secondary victims. Now, there are a few cases that are very, very important. The two main ones are the case of Alcock and also the Taylor and Anovo case. But then there's also cases that are going to the Supreme Court and will probably be adjudicated on next year that we're probably going to have to do an update video on in the future. So let's get into how the law is applied to those who are considered to be or try to establish themselves as secondary victims in psychiatric injury. So the test for secondary victimhood, it comes from the landmark case of Alcock. Now, the case of Alcock from 1992, Alcock and the Chief Constable of the South Yorkshire Police, is a case which involves the Hillsborough disaster in terms of the facts. It was a series of claims, essentially all in relation to the Hillsborough Football Stadium disaster. For those of you who do not know, the Hillsborough disaster was it was a football game. I believe Nottingham Forest and I can't remember the team they were playing against. Essentially, there were too many people who were in the stadium, and there was fencing in place, which meant that they couldn't go anywhere. And a number of people got crushed, and it caused a number of deaths. And people had to run out into the pitch. A lot of people died, and the result was a number of different claims on and against the South Yorkshire Police. One of which was including the fact that they essentially had let too many people in than was necessary, or that could be incapacity. So ultimately, these were a number of cases which did not affect the individuals who were actually victims of the disaster itself, but we're talking about people who perceived the disaster and then suffered psychiatric harm as a result of their perception of the event, okay? The claim came from a number of people who had tangential relationships to those who had died in the disaster. And because it was multiple different claims, there were varying different levels of quote-unquote closeness to the people in the event. So some of them were, I believe some of them were friends, some were brothers, some were marital relationships. So yeah, two were brothers. of one of the victims who were at the site and had witnessed the death of the victim. So they were there in the midst, and they saw their brother who had, or they saw a sibling who had died as a result. One was the brother-in-law, and they were also at the disaster, present at the disaster. There were some who were relatives who had seen the injuries of their loved ones on TV. So they were not at the disaster or in any kind of danger, but they'd witnessed the event on television. And so the question here is, which of these, or how many of these, or if any of them, could actually claim as secondary victims? Who can claim as a secondary victim for the purposes of the tort of negligence and therefore be successful against the Chief Constable of South Yorkshire Police? Given the fact that there were a number of different claims from varying degrees of different levels of closeness in terms of closeness to the event, as well as closeness to the people who were at the event, the courts had to think about essentially establishing some kind of test to allow for us to adjudicate on cases of secondary victimhood. All the claims ultimately would be dismissed, and applying 3 factors would be a requirement in order to determine secondary victimhood. And this is really where we get the 3-stage test ultimately for secondary victims, okay? The 3 considerations must be as follows. The people must have a close tie of love and affection. This relates to the relationship that you have with the person, okay? So the person has to be somebody of a close tie of love and affection. Again, this is generally quite vague, and it is up to interpretation, and the tests essentially will require cases to come to a court to see if they actually apply. So brothers, for example, may qualify, marital relationships, father and son, parent and child, for example, that kind of thing, maybe even best friend, all of which could, again, have this prerequisite requirement of close tie of love and affection. The second consideration is proximity to the victim in terms of space and time, okay? So the victim, of course, is the essential focal point for the traumatic event. That when we talk about secondary victim and secondary victimhood, we are talking about a person who has essentially witnessed something that is traumatic happen that's caused them to have a psychiatric injury. And the traumatic event that happens is obviously the result of negligent action, hence why we're talking about the law of tort. So the victim in these cases are not the people who are bringing claims. They're not the claimants who are trying to make a claim for secondary victimhood. Instead, they are the people who actually suffers some kind of, or at least they're the source of the traumatic event. So the victims in this case, for example, were the people who were severely injured or killed in the Hillsborough disaster. Okay. So in order to make a claim as a claimant for secondary victimhood, there must be proximity to the victim in terms of space and time. So not only do they have to be around near the victim at the time at which the event happens, but they also have to, like I said as well, be close to the victim in terms of spatially. And then finally, the final consideration must be that the shock come through the physical senses, okay? So what does this mean? Well, this essentially means that you have to either hear or witness the event through the physical senses. So we'll get to some of the considerations in a second about this, but this is essentially the 3 considerations that are required for us to establish a successful claim of secondary victimhood. This, bear in mind, is just the requirement for secondary victimhood in psychiatric injury. The next the things that you have to do before even all of this is firstly have to show that the damage to a victim was caused by negligence, was a negligent incident that was caused by the defendant, and that you have to also have a recognized psychiatric condition. These are the 2 requirements for any psychiatric injury claim. It has to come from negligence or some kind of tortious activity that was also something that caused a recognized psychiatric illness. We've established this in previous lessons. And then on top of that, you have to think about the considerations if you want to try and make a claim as a secondary victim. Okay? This approach was adopted from the case of McLaughlin and O'Brien. Now, how is this approach adopted in future cases? Well, let's think about the case of Taylor and Enovo from 2013, because the facts of this case are very interesting. Essentially, it was a claimant, and the claimant was the daughter of someone who had had a workplace accident. Okay, so somebody had had a workplace accident, the claimant was the daughter of that person. The accident by her mother resulted in her suffering something known as a thrombosis, which would kill her 3 weeks later. Okay, so you have a thing that takes place, a thing that was the result of negligence, the workplace accident, and then 3 weeks later, the thrombosis takes place, which actually kills the mother. Okay, now the claimant had witnessed the death of her mother and had developed PTSD as a result of witnessing that death, a very traumatic experience, I'm sure, but she had not witnessed the accident, okay, because the accident was done at work. It was a workplace accident that had taken place 3 weeks prior, okay? This is where the negligence derives. The negligence derives from the workplace accident, but the death and the psychiatric injury, the PTSD, derives from the death of the mother, which takes place 3 weeks later. The question is, how do we fit the considerations for secondary victimhood to this case? Could she make a claim for psychiatric injury as a secondary victim against the employer who was negligent in the causing of the workplace accident? Well, it was held that she could not. It was argued that the important event which requires proximity. So remember, if we go back to the considerations from the case of Alcock, if this works here, if we go back to the consideration for the case of Alcock, the second consideration is that there must be proximity to the victim in time and space. That proximity element, okay, the proximity element that was required was not proximity to the victim when the victim died, but proximity to the negligent action, i.e. proximity to the workplace accident, which she did not satisfy because she wasn't there when that workplace accident had taken place. The other two were reasonably easy to consider. It was a mother, so close ties of love and affection would apply. It was also a shock that was seen and experienced through the physical senses. She witnessed the death of her mother, and as a result developed a recognized psychiatric condition, i.e. PTSD. The thing that failed in this case, in Taylor and Enovo, is the idea of proximity to the victim in time and space. The proximity was not present. It was present at the death of the mother, but it was not present at the time of the workplace accident. Now, the final case I want to talk about is the most recent case that is going to the Supreme Court as we speak, the case from 2022-23 of Paul and Royal Wolverhampton NHS Trust, which is going to be very, very important when we talk about deliberating on cases of secondary victimhood. And if you're somebody who is studying Tort right now and is preparing for exams in sort of July or May, June time, towards the end of this academic year, you should probably be familiar with this case and the update that this will probably bring very, very shortly. So this case was one which involved medical negligence, hence Royal Wolverhampton NHS Trust being the defendants. A medical misdiagnosis had caused a primary victim to die of a heart attack just over a year after. Okay, now by primary victim, we're talking about somebody who actually has suffered and has been killed as a result of a medical misdiagnosis, negligent action, medical negligence. This was an event which was witnessed by one of the family members, and it was held at the Court of Appeal that if we apply Taylor to the instances of medical negligence, i.e. the case of Taylor and Enovo, we find that we get the following point. We see that if I were starting with a clean sheet, I can quite see why secondary victims in these cases ought to be seen to be sufficiently proximate to the defendants to be allowed to recover damages for their psychiatric injury. Since, however, this court is bound by Taylor and Enovo, it is for the Supreme Court to decide whether to depart from the law as stated in that case. So, essentially, the Supreme Court is going to decide in 2024, next year, or this year, when this video is released, okay, that the case of whether or not the case of Taylor and Enovo ought to be rejected. The ruling from Taylor and Enovo ought to be rejected to essentially allow for cases like this where a primary victim dies in front of some other individual, often a family member, and that causes them to have a recognized psychiatric injury, whether or not that event is the proximate event that is required for secondary victimhood, rather than the original negligent event which takes place earlier on, often during medical negligence or the workplace accident in the case of Taylor and Inovo. So you can understand both sides of the perspective. Okay, on the one hand, you can understand the rationale in this passage, suggesting that, well, there was a close tie of love and affection because this is a family member. There was the perception of the event through senses. They saw this person have a heart attack and die. Okay. And there seemingly was proximity to a traumatic event. The traumatic event being the death of the person to whom you are a close family member of. So you can understand why, applying all of those three considerations that we established in Alcock, that you can come to the conclusion that this should be a secondary victimhood claim and it should be successful. But then you can also understand the ruling and the rationale in Taylor and Inovo, because the heart attack that was caused by the medical misdiagnosis was a heart attack that takes place over a year later. The actual negligent event, the event to which there was tortious activity, there was tortious negligence, the defendant actually did something that was negligent, was over a year ago. Okay, and so you can understand the reasoning and the rationale in Taylor and Inovo to establish that the proximity should be the proximity to the negligent event, not just the proximity to the traumatic event which takes place a year later. You can understand both sides of this of the coin, and it is up for the Supreme Court to decide in this year, essentially. So we'll do an update on this in the future when this judgment comes out. It's going to be a very big judgment, I assume. And so stay tuned for that if and when the Supreme Court actually get around to making a decision on this particular case. In previous lessons, we've been talking about psychiatric harm. We've been talking about the ways in which a claimant, should I say, can make a claim for psychiatric harm, depending on the various different circumstances, whether or not an individual may be able to claim with psychiatric harm as part of a broader negligence claim, so in conjunction with an injury, for example, or whether or not they can claim for something known as pure psychiatric harm, i.e. where there is no physical injury attached, where it is just psychiatric injury. And the determination that you make there is whether or not they are a primary victim or a secondary victim. What I want to do in this video is focus a little bit more on the concept of secondary victimhood in more detail, and focus on this idea of sudden shock. Because sudden shock, as cited in the case of Alcock, is a very important requirement for showing secondary victimhood. And we will see, and it will be illustrated in some of the case law, that sudden shock is particularly important for this particular area. So it is a requirement for secondary victimhood in psychiatric injury for there to be sudden shock, and this is affirmed in the case of Alcock. And we'll get to what this means in a second, but ultimately if we just reevaluate the case of Alcock for a second, we will remember that it was the case which involves multiple different claimants in multiple different ways and having multiple different relationships to victims of the Hillsborough disaster, the football stadium disaster which takes place, which kills a number of individuals owing to the fact that too many people were essentially packed into the stadium. There was no room and nowhere for them to go, and people got crushed to death. And there were various different claims, all of which were dismissed on the basis of the fact that in order to be a secondary victim, you have to satisfy three requirements. You have to have a relationship of close ties and love and affection to the victim. And by victim, I'm talking about the person who actually died or was seriously, severely injured as a result of the negligent actions of in this case, the police. Okay. Or that's the first requirement. So things like familial relationships, very close friendships, all these kinds of things, marital status often fall into that category. You also have to have proximity to a traumatic event. So you have to actually have been close to the traumatic event in some kind of way. And then the final requirement is that you have to have seen the event through unaided senses, i.e. you have to have actually had perception of it, namely either through hearing or through sight. And so when these three requirements are satisfied, then you can potentially claim for secondary victimhood. Now, the additional requirements are, of course, that there has to be a recognized psychiatric condition, and that the action that brings this on and actually causes damage to a primary victim, i.e. a victim who is either severely injured or killed, has to be the result of negligence as well. So obviously, at the beginnings and the fundamental bedrock of all of these claims, you obviously have to have negligence, because this is a tortious activity and a tortious claim that you're trying to bring about. Now, sudden shock is also a requirement. So sudden shock is something that is established in the case of Alcock, because they say that shock in the context of this course of action involves the sudden appreciation by sight or sound of a horrifying event, which violently agitates the mind. Okay, that's as taken from the Giliker textbook. Ultimately, then, therefore, when we think about sudden shock, what sudden shock is the appreciation by sight or sound of a horrifying event. So if a horrifying event takes place, a family member is brutally injured or killed in a way which is the result of negligent action, and this violently agitates the mind. It's not a requirement, and it's not a psychiatric condition which develops slowly over a period of time. This suddenly agitates the mind because of the appreciation of the horrifying event by sight or by sound. Now, generally speaking, you should already have an understanding of what sudden shock actually is. A sudden and violent reaction almost to the horrifying event, rather than a gradual development of psychiatric conditions over the course of a period of time. But let's look at the case law that gives us a bit more indication of how this is illustrated. So we have the case of Sion and Hampstead Health Authority from 1994. In this case, the claimant was a father who had witnessed his son suffer a significant injury in a motorbike accident. Now, his son, over a period of weeks, would slowly deteriorate in terms of his condition, his health condition, as he slips into a coma and then subsequently dies. Okay, so the process by which this traumatic event takes place is over the period of 2 weeks. It's a particularly slow and debilitating way of dying, and it's not particularly pleasant. Now, the question here for the courts was whether or not the father could make a claim of psychiatric injury on the basis of secondary victimhood, given the fact that he had witnessed his son die. Okay, now there are a few things that we have to consider here. Okay, of course, we have the motorbike accident being the result of negligent action, so you can already tick that off as being satisfied requirement. Even if this wasn't the case, let's just assume for argument's sake that it was, because our considerations here are on the psychiatric injury part, not necessarily the negligence part. The psychiatric injury that was developed was one that was recognized, so let's just tick that off and assume that that is also true. The question for the court is whether or not this idea of sudden shock is satisfied in this case, because the witnessing of his son's death was something that takes place not at an instant point. It wasn't immediately as the motorbike accident takes place. He didn't die straight away at the scene of the accident. Instead, he dies over the course of 2 weeks, slowly deteriorating and slipping into a coma. Well, the question here is, does he satisfy the sudden shock requirement? Was this sudden shock? The claimant was denied a claim because the illness didn't come from sudden shock. Rather, it came from an expected death. It was expected, and he was told of the fact that at least a few days, potentially even right at the beginning of the 2 weeks in which his son would slowly die, that his son is probably going to die, and then eventually, when he slips into a coma, it is almost confirmed that yes, your son will die, and he will die very soon. So this is not something that is suddenly agitating the mind in terms of the witnessing of a horrific event. This is a slow deterioration of a loved one, which ultimately leads to the death of that individual. This is not to suggest that this person did not suffer psychiatric injury and psychiatric harm. They suffered a psychiatric condition. Obviously, anybody would, but that this was the result of and could make a successful claim in negligence on the basis of secondary victimhood is the thing that was debated and the thing that was ultimately rejected. In 2015, we have the case of Liverpool Women's Hospital and Ronnie. From 2015, as I just mentioned. This case was a case which involved the claimant's wife who had a botched surgery which was the result of medical negligence. Okay, so negligence is already assumed in this particular example. The result was that she had to go through an emergency treatment. The claimant in this case had suffered and developed PTSD as the result of seeing his wife in intensive treatment. You would probably imagine that this is something that you would definitely be sympathetic to the idea that an individual seeing his wife going through intensive care, the result of emergency treatment, which could have resulted in the death of his wife, developing PTSD as a result. Now, again, in this case, the claim for secondary victimhood was rejected on the basis that the PTSD was not the result of a sudden shock. It was not the result of some violent agitation of the mind as the result of perceiving either through sight or through sound the horrific accident occurring to a loved one. Sudden shock requires sudden appreciation by sound of or sight of a horrific event which agitates the mind, and so the result of this is that the claimant in this case could not make a successful claim for secondary victimhood either.